Well, thank you, Mr Deputy Speaker. It's a great pleasure to see you in the chair, and I want to rise to discuss a very important and serious matter, and that is the issue of SERCO and its announcement to press ahead with asylum seeker lock change evictions. And just to give a bit of background, sir, I will be mentioning a number of organisations who have expressed their concerns both publicly and with myself: the Scottish Refugee Council, Positive Action for Housing, the Govan Law Centre, the Govan Community Project, Glasgow City Council and the Scottish Government, and of course the Tenants Union, the Living Rent Campaign, whose badge I proudly wear today. Now, earlier this month, SERCO announced it was going to restart its inhumane lock-changing programme, which could leave hundreds of asylum seekers homeless and destitute in the city of Glasgow. And I'm calling, as well as my colleagues in the SNP group, to prevent these evictions and future evictions from taking place. SERCO, of course, currently have a contract with the Home Office about the provision of asylum accommodation in Scotland. And the recent threat to evict 300 asylum seekers onto the streets of Glasgow without any consultation only strengthens the argument that a public sector bid for those contracts would have been the best way forward, because, as my honourable friend will know, who serves on the Select Committee, the Home Office Affairs Select Committee, in January 2017 it published a highly critical asylum accommodation report which made system-wide recommendations and also uncovered unacceptable housing standards, insufficient recognition of needs such as mental health, torture, sexual violence and trafficking, as well as serious questions around the rigour, consistency and a similar lack of public transparency in the Home Office's performance management regime of its 3 housing contractors across the United Kingdom. Now, Mr Deputy Speaker, I don't want to discuss, it wouldn't be right to discuss the merits of live legal proceedings in this place, but it is a concern that I have a constituent, Mr Deputy Speaker, who has live legal proceedings in Scotland's Supreme Appellate Court, the inner house of the Court of Session, and I'm surprised that both the Home Office and SERCO have decided to press ahead with these lock change evictions while this matter is still to be settled in the courts. And I do have a concern, Mr Deputy Speaker, that the labelling of asylum seekers as failed is the sort of language that we should not be using to discuss some of the most vulnerable in our society. The asylum system and process can be very long, it can be very lengthy, it can be very complicated, and I think using labels such as failed is entirely unhelpful. Now, the Scottish Refugee Council have also expressed their concerns, Mr Deputy Speaker, in light of SERCO's announcement on the 12th of June, which was announced to Glasgow City Council, Scottish Government, but not members of Parliament, incidentally, from Glasgow. We did not get that until we saw the press release. The public statement caused great concern, and of course we were then written to by the Immigration Minister on the 17th of June regarding this announcement and the lock change eviction plan. Now, it's clear that it's a coordinated action between both the Home Office and SERCO, and like the Scottish Refugee Council, I oppose these actions, and I want to focus on some of what SERCO are up to. I would say firstly, Mr Deputy Speaker, no one should be rendered street homeless, and certainly never ever without the protection of court due process. There is a wider strategic importance in Glasgow, as Glasgow continues to resist and overcome the clear housing and due process gaps in the current asylum system. And that will have relevance to other parts of the UK, especially other asylum dispersal areas, such as the north of England, the Midlands, South Wales and Belfast. We are clear what is happening here in Glasgow, with multinationals like SERCO intending to evict vulnerable people and render them immediately street homeless through callous, traumatising and possibly still unlawful lock changes. These are the extreme symptoms of a failed and broken approach by the Home Office to their responsibilities in the Refugee Convention and EU asylum legal instruments to prevent destitution of those seeking refugee protection. I'll give way on that point.
I'm very grateful to my honourable friend both for his powerful speech and for bringing this debate in the first place. He just mentioned some of the local authorities that have stepped up to the plate to take dispersal of asylum seekers into the local authority areas. Would he agree with me that other local authorities who may have been interested in becoming dispersal authorities and stepping up to that plate will be completely put off doing so by this horrendous process that they've witnessed in Glasgow?
Well, I thank my honourable friend for raising that point, and I'm going to express later on the real views of local government. But he is correct that there are local authorities who were considering becoming part of the asylum dispersal process, who are now minded not to, as a result of what they're seeing in Glasgow and the announcements from SERCO in relation to lock change evictions. Mr Deputy Speaker, there should never be anything inevitable about destitution from any system of support, be that social housing, social security or with asylum accommodation. The decade-long devaluation, underfunding and outsourcing delivery of this public service of housing to women, men and children seeking refugee protection has been part of a wider austerity project that has penetrated deepest into communities of entrenched multiple deprivation across the United Kingdom, including in Glasgow. We should always remember that it is these areas, however, that have consistently welcomed people seeking asylum through the Home Office's asylum dispersal programme. The consequence is that those communities and council areas and third sector services have, as we see in Glasgow, stepping up to help despite having unfairly the responsibilities and costs to help people in their time shunted over two of the most powerful institutions in the UK, namely the Home Office and multinational companies like SERCO, who are enjoying profits of £30 million, and that basically exists only to win public service contracts, especially from the UK government departments, in, for example, immigration and asylum, but also defence, transport and other spheres. Now, the Scottish Refugee Council have had to increase its destitution service provision and are influencing their advocacy activities, accelerating their work with key partners such as Positive Action in Housing, with Shelter Scotland and Just Right Scotland, coordinating the charity legal sector collaboration against these proposed evictions. It has met regularly since August 2018 to share information and take actions via litigation, legal policy and campaigning. Other members include Legal Services Agency, the Latta Law Firm, Govan Law Centre, the British Red Cross, Asylum Support Housing Project, the Refugee Survival Trust and, of course, the Great Govan Community Project. They've had to consider the immigration's descriptions of the Scottish Refugee Council in the 17th of June letter that was issued to Glasgow constituency members of Parliament, and it is the Scottish Refugee Council's strong view that there were inaccuracies in that letter, and I want to come on to them now. Now, while the Scottish Refugee Council recognised that the Home Office, through its advice contractor and migrant help, have made efforts by letter and telephone to contact those at greater risk of evictions by lock change notice since November 2018, these efforts, however, have stemmed largely from advocacy by Glasgow City Council and the Scottish Refugee Council to the Home Office in the Glasgow Asylum Task Force. Furthermore, the Scottish Refugee Council and other members of the task force persuaded the Home Office to initiate a support referral process. This was a pilot and comprised migrant help in Glasgow, offering each individual at risk of an eviction of a 1.5-hour appointment. The pilot had two phases, first from November 2018 to January 2019, involving migrant help only. The second from February 2019 to April 2019, after migrant help sought assistance from the Scottish Refugee Council. The Scottish Refugee Council received 61 referrals from migrant help in the second phase of this process, but that compares to 419 individuals which the Scottish Refugee Council destitution advisors from April 2018 to March 2019, 263 of which were on SERCO asylum accommodation. So through sustained funding from a charitable organisation and short-term resources from the Scottish Government, they've managed to stretch limited funds to prepare and lodge 120 applications for Section 4 support, with 59% of those being successful, thereby lifting or preventing 72 individuals from destitution. That's been achieved outside of any Home Office support, And I think that we would all want to continue to urge the Home Office, as a state party to the Refugee Convention and EU asylum legal instruments, to urgently provide resources that are genuinely commensurate to need, so including funding, independent advocacy support to help individuals in grave need. I'll give way in that point.
I'm grateful again to Marvel Fenn for giving way. On the point of funding, one thing that the Home Affairs Committee did recommend towards the end of last year was direct funding to organisations and to city councils in dispersal areas, because this undoubtedly has cost implications for them, being a participating dispersal authority. Does he share my frustration that the work that the Home Office undertook to carry out with local authorities to calculate the funds that would be needed really seems to have been put in the back burner and kicked into the long grass, and it has to be done as a matter of urgency?
Well, I do agree with the urgency that my honourable friend suggests, and I'm sure the Minister will come on to that, because there's a very real concern, not just from independent advocacy groups, like, for example, the Scottish Refugee Council, but again from local government and the Scottish Government, and I will come to that later on in my remarks. The priority remains, Mr Deputy Speaker, to help all those in or facing asylum destitution, especially those due to receive the 14-day notice to quit letter, followed by a 7-day lock change notice. Destitution advisors provide a holistic assessment of need and ongoing support and coordination, and that includes individuals under threat of eviction by lock changes from SERCO. All these individuals are known to the Home Office. The process of submitting new evidence for a refused asylum claim is lengthy and complicated for most who might not have an option to return because of fear of persecution. To simply say that they refuse to leave is not accurate. The emphasis must be that the actions of SERCO in this sphere of functions of a public nature are covered under the scope of the Human Rights Act 1998. This legal status was confirmed in a Court of Session decision. Now, Mr Deputy Speaker, I think it's important today that we highlight just some of the individuals who are under threat of eviction by SERCO and the Home Office. We've been advised by the Home Office and the Minister at a meeting we had with the Minister earlier on this week that those with vulnerabilities will not receive such letters. But I have to say, Mr Deputy Speaker, that does not seem to be the case. And I'm going to mention just a number of cases that I have that have been presented to me by asylum charities. Now, everyone here knows, Mr Deputy Speaker, the safety and belonging that a home brings. But today in Glasgow, we are on the brink of a humanitarian crisis of hundreds of women and men who sought sanctuary in the UK. The Conservative Government has nonetheless retained its basic inhumanity in the asylum process. Since last week, it's been rolling out ruthlessly its privatised hostile environment in Scotland's largest city. Courageous women like Miriam, who has fled abuse in Eritrea, but has been refused refugee protection by the asylum system, should never have received a notice to quit. Why, Mr Deputy Speaker? Because Miriam has depression, is receiving medication and is being helped by her community psychiatric nurse. But SERCO have proceeded to order her to get out her house, which means no protection against street homelessness, no rule of law or court oversight, and then to be callously ensuring trauma, to be torn away with immediate effect from her only source of shelter, to be given a lock change letter. Do we leave people like Miriam, Mr Deputy Speaker, on the streets with her mental health going through the floor, a sitting target for the trafficking or exploiters, something that the outgoing Prime Minister has said was her top priority? Can the Minister tell us, does she realise that those sorts of decisions feed exploitation and are bound to organised crime, whilst of course destroying lives? Surely the decent thing that can be done is to ensure that Miriam's lock change letters are cancelled. Now, Mr Deputy Speaker, I also have another concern, and that is that it's been brought to my attention of the number of cases, the number of other cases which I'm going to mention, are being delivered by two men in uniform, handing these letters to many individuals, some of them women who live on their own. I have a real concern and I have to say that I find that completely and utterly unacceptable. A woman who has fled and come here to the UK, who wants to seek shelter and seek asylum in the UK, will find that two men in uniform who visit their house with letters means something completely different to them than it would perhaps to someone like us. And it really is unacceptable, and I hope the Minister will have something to say about that. But I have a number of other cases. A 34-year-old woman from Eritrea who was issued with an eviction letter dated the 12th of June 2019. Not the 20th of June, as MPs have been advised, Mr Deputy Speaker, but the 12th of June, telling her to leave her accommodation by the 25th of June. The letter wrongly stated that she had received a positive decision. It also incorrectly advised her that she must leave and should have to apply to Glasgow City Council for rehousing. That individual's hopes were raised that she had got refugee status. A week later, the same woman received another letter dated the 19th of June, again telling her to leave by the 25th of June. This time the letter wrongly stated that her asylum claim was refused and that she must leave her accommodation. In fact, this woman has an ongoing asylum claim, and she is due to attend a further submissions appointment in Liverpool on the 4th of October 2019. This woman's claims for asylum is based on her nationality and the fact that she is a Pentecostal Christian, and that she would be at risk of persecution should she return. Mr Speaker, another case I have that's been presented to me is a 72-year-old gentleman who's an Iraqi national but has lived most of his life in Syria. He left Syria when the war started. He's lost contact with his wife and children in Europe and is in Glasgow alone. He speaks Arabic. SERCO sent him a lock change eviction letter dated the 19th of June, telling him to leave by the 2nd of July 2019. He has a serious heart condition for which he's had a heart operation. He also has a problem with his spine and breathing problems, which leave him bedridden most of each day. He is particularly vulnerable due to his age, his ill health, and English not being his first language. And he is traumatised by his experiences. And it's a real concern that he'll be unable to safeguard his own well-being and is at risk of neglect. And Positive Action in Housing have asked the Glasgow City Council Social Work Department to carry out a community care assessment and is seeking out possible legal support. Another case, Mr Deputy Speaker, a woman, 58 years old, received a letter from SERCO dated the 21st of June, telling her that her entitlement support ends on the 23rd of June, less than 2 days' notice. If she leaves her accommodation, she'll be absolutely destitute. This woman's Section 4 application is underway and her legal case is ongoing. And this woman left Gambia to ensure her daughters cannot be subject to FGM practices. Another case I have, Mr Speaker, is a constituent who received a letter on the 12th of June, who actually visited this Parliament as part of a delegation from the British Red Cross, an African lady who identifies herself as a member of the LGBT community, who feels she can't go back to her country. She was issued with a letter the 12th of June, not the 20th of June. Mr Deputy Speaker, it does appear that SERCO are treating individuals with complex cases like one mass of people. And this is likely to lead to unjust decisions and vulnerable people with a genuine reason to be here being ejected from their accommodation. As a landlord, SERCO is ill-equipped to pass judgment on someone's asylum status. Walking unannounced into someone's accommodation and rummaging through their private belongings does not make them an immigration officer. The people they are attempting to evict are not subject to deportation orders. The Home Office support is stopped for now, but that does not mean their cases are, to put it in inverted commas, failed. They can still engage with the legal process and apply for support to be reinstated. Appeals and judicial reviews do happen and are often successful. Now, Mr Deputy Speaker, I want to come on to the local government view and a letter which I have with me, which I'll place in the library, from Susan Aiken, the leader of Glasgow City Council, and a note of the meeting of local authorities passing their concerns about the asylum accommodation contracts and the processes. And there are pressures in different areas, including the North East, Yorkshire and Humber, Glasgow, as incoming contractors face the need to procure a large number of properties in a very short period of time. And it's my concern that SERCO are advertising the fact that the reason they need to remove asylum seekers from accommodation so they can hand the keys back to the original landlord. That does not seem to me to be an acceptable reason. There's a very real concern from local government, Mr Deputy Speaker, that the transition deadline won't be met in some areas and contingency accommodation may have to be used. The distribution of asylum seekers across the country is very uneven and in areas of high concentrations, including in Glasgow. And local authority leaders from other parts of the UK agree that we need to progress the funding issues as local government are left to pick up the tab for the decisions being made by both SERCO and the Home Office. The Home Office, in their view, is failing to address issues for which they have responsibility and seen unable to provide up-to-date data on the number and locations of asylum seekers. When data is produced, it's often incomplete and contradicts information available from other sources. And in the view of the local authorities, nothing is being done by the Home Office to convince other local authorities in the UK to participate in the dispersal programme. But as we've heard from my honourable friend, the fact that asylum seeker lock change evictions are going ahead has resulted in some local authorities suggesting that they would not want to participate in that sort of process. The Home Office response to the request for funding from local authorities participating in the dispersal programme, they are still waiting and they see no evidence that that has been taken to Her Majesty's Treasury. So we have a number of questions, Mr Deputy Speaker, I think it would be fair to say, in relation to what is going on in relation to both the contracts and this inhumane move to subject asylum seekers to lock change evictions and to make them homeless. So I have a number of questions for the Minister, but before I do, I have to say that I am very concerned at the behaviour of SERCO. And I want to reiterate it again, Mr Deputy Speaker. Two men should not be approaching women living on their own or with children and going in with threatening letters and handing them that way. That is, I think, something that I would want to hear the Minister condemn, and I would want that practice put a stop to. So can the Minister answer the following questions? I have a number of questions for her. Has she, or does she intend to come to Glasgow to witness a lock change eviction? When is she next coming to Glasgow to discuss with asylum charities and the Council the asylum accommodation contract? Does she realise that someone who comes home tonight and finds the locks have been changed, what that would mean for a particular individual? Can we have a guarantee that no one in Glasgow has or will receive a 14-day notice to quit or a 7-day lock change notice who has vulnerabilities as defined in the Home Office safeguarding policy? And I'm going to ask the Minister if she will publish the Home Office safeguarding policy, because the 4 cases that I have presented, Mr Deputy Speaker, would, to my mind, qualify under someone who has a vulnerability and would surely qualify for someone who would be defined in the safeguarding policy. Could the Minister tell us a bit more about what the Home Office define as the overstaying group, and do they have a list of those in the overstayer group? Can she also confirm that refused case management and immigration enforcement teams, are they planning to start working through the overstaying list? Are they planning to detain people at their reporting events in Glasgow? Or can she assure me that that will not happen, and indeed has not and never been discussed since the first SERCO evictions announcement in July 2018, last year. And can she give us an assurance that no one in the overstaying group will be visited by immigration enforcement in their asylum accommodation purely because they are classed as an overstayer? Mr Deputy Speaker, I think the Home Office today, as a result of what has been put forward, is required to make a decision. You will have heard the rumours, as I have, Mr Deputy Speaker, that the shredding machines in government departments are in overdrive, working overtime, prior to the new Prime Minister and the new regime that's going to take place. But given the facts that have been presented today, well, you've heard the rumour now. Given the facts that have been presented today, the Home Office must now call a halt to these eviction notices. Everything we've been told, Mr Deputy Speaker, in good faith, everything we've been told by the Home Office in good faith as to how this will work in practice has been shown not to be the case. Letters were issued before the 20th of June. We were told that no letters were issued before the 20th of June. We were told that those with vulnerabilities would not receive letters, and we've shown that not to be the case. And the style of how those letters have been delivered, I think, is completely unacceptable at any level, and I hope the Minister will agree with that. So I'm asking her today, as a result of what I've put forward, which are the facts clearly given to us by asylum charities, to ask the Minister to call a halt to these evictions. Now, Mr Speaker, I will say this in closing. Both the Home Office and SERCO must know this. They have picked the wrong city. The city of Mary Barber and the rent strikes just over a century ago. The city of the great Glasgow girls who campaigned against child detention and ensured they got their school friend back. And there are thousands of volunteers, Mr Deputy Speaker, signed up by the Living Rent campaign, on standby and ready to step in and prevent these evictions. The government should be in no doubt that if it requires Glaswegians to protect the basic rights, the basic human rights of others, by using their human rights, that is what will be done. And that right that will be chosen is the right of peaceful assembly. And, Mr Deputy Speaker, I will say this now, that I will join my fellow Glaswegians to prevent these evictions. Thank you.
Caroline.
Thank you, Mr Deputy Speaker, and I thank the Honourable Member for Glasgow South West for having brought this debate and providing me with the opportunity to clarify the current position in Glasgow regarding those who are no longer eligible for asylum support or accommodation. The United Kingdom has a proud history of providing an asylum system that protects and respects the fundamental rights of those individuals who are seeking refuge from persecution. This government is committed to working closely with communities and stakeholders to ensure destitute asylum seekers are provided with safe, secure and suitable accommodation, and that they are treated with dignity while their asylum claim is considered. However, it is important to recognise that the majority of the affected cohort in Glasgow do not have status in the UK. They have sought asylum, their claim has not been substantiated, they have exhausted the appeals process and now need to take steps to return to their country of origin. I will indeed give way.
Even if some, and I'm talking about some of these individuals, have not qualified and haven't met the technical definition of what a refugee is, that doesn't mean they are not vulnerable people. It doesn't mean they have significant needs, and it doesn't mean they shouldn't be treated with dignity as well. Why can't we have why do we have this cliff edge process, which means that even if an asylum claim is refused, there are no alternatives looked at, and there are no ways to try and work with that person to look at alternative ways to ensure that they are looked after properly?
Well, at no point, Mr Deputy Speaker, have I said that these people are not vulnerable. I have tried to set out that they have had an asylum claim which has not been found to be valid, and that they have been through the appeals process. And if the Honourable Gentleman will give me some time, I will move on to discuss the various means of support that are available, particularly to those who are vulnerable and those who have medical conditions, those who have children, of which we have heard some earlier. Can I just make some progress, please? The system that operates in Glasgow is the same system that operates across the United Kingdom and has been operated by successive governments since the introduction of the Immigration and Asylum Act of 1999. Asylum seekers and their dependents, who would otherwise be destitute, are provided with accommodation and a weekly cash allowance by the Home Office while their asylum claim and any subsequent appeals are considered. This form of support is usually known as Section 95 support. If an asylum seeker is granted refugee status, they are free to take employment and become eligible to apply for mainstream benefits in the same way as British citizens and other permanent residents. If their asylum claim is refused, but they have children at the time their appeal rights are exhausted, they remain on Section 95 support until their youngest child reaches 18 years of age or they leave the UK. Those without children who exhaust the appeals process lose access to Section 95 support, but a very similar form of support, known as Section 4 support, is provided so long as they take reasonable steps to leave the UK or, importantly, show that there is a legal or practical obstacle that prevents their departure. Examples of such an obstacle include those who are too sick to travel, those who need time to obtain a necessary travel document, and those who have made fresh submissions against the refusal of their asylum claim that have not been resolved. I will indeed wait.
Well, I thank the Minister for giving way. I think that this is an important point in terms of someone's status and their appeal. Now, my understanding from what the Minister has said is that someone who has been refused at an upper tribunal level is someone who could be subjected to an eviction letter. So is the Minister then saying that those individuals have effectively 14 days to submit either fresh evidence, an Article 8 report, an Article 8 application or the like, because someone who has been refused at an upper tribunal level still has rights to submit a fresh claim?
Well, the honourable gentleman is right to point out that they have the right to submit a fresh claim, but I'm very anxious to emphasise that what we cannot encourage is a circular process where people submit claim after claim when a first-tier tribunal and then an upper-tier tribunal has found their claim to be unfounded. Now, circumstances may change. I absolutely accept that. But it is important that we treat the individuals fairly, but that the system is upheld. So decisions to refuse Section 4 support do attract a right of appeal to an independent tribunal. And it is clearly reasonable to limit the offer of Section 4 support to people who satisfy these conditions. Providing support indefinitely and without conditions to people who have no right to be in the UK is wrong in principle and risks undermining public confidence in the asylum system. Whilst I have said that it is right that people who have no legal basis to remain in the United Kingdom are not supported indefinitely, it is also right that they should be aware of their options and the advice and support available to them. Advice on accessing further support or returning home with support is routinely provided to all whose claim has been refused. However, in the case of this particular cohort of people, we have gone further, and since August 2018 have been working with partners in Glasgow, including the City Council and the Scottish Refugee Council, to ensure that affected individuals are aware of the further support available to them. Migrant Help, on behalf of the Home Office, has been reaching out to those affected to explain how they can continue to be supported and accommodated if they take the necessary steps to return to their country of origin. We have also provided information on our Assisted Voluntary Return Scheme, which provides up to £2,000 in reintegration assistance. Migrant Help has contacted 373 people to discuss these options and conducted 154 advice appointments. The Home Office has also held over 296 conversations about voluntary return. The scheme available is designed to assist those who require more help and includes supporting resettlement in the country of return by providing financial or in-kind support from an overseas provider. I should note at this point that a minority of the affected individuals have received a grant of leave to remain, but have nonetheless refused to leave their accommodation at the end of their eligibility. We are working closely with Glasgow City Council on these cases and have an agreed process to move these individuals into appropriate local authority housing and to access mainstream benefits. Indeed.
Again, she's been most generous, so can the Minister just clarify then if those who are potentially subjected to a lock change evictness notice over the next few weeks are those who have right to remain?
Well, as I was saying, there are a small number of people who have been granted refugee status, but it is absolutely right that they then move on from accommodation that is designated for destitute asylum seekers so that the next cohort of asylum seekers can move into that accommodation, and those refugees, those who have the right to stay, to live, to work in this country, move into accommodation that is appropriate for their needs and is not specifically designated as part of this assisted asylum supported accommodation, which is specifically designed for a cohort of people who are still in the claims process. As the honourable gentleman will know, I have also written to all Glasgow MPs with a direct line of contact to Home Office teams who can work on a case-by-case basis should they have any questions or concerns. All applicants involved have been notified that they can contact their MP for advice and that their MPs have a direct line to the Home Office. I know there has been some concern raised about the legal position in relation to the issuing of lock change notices, which I would now like to clarify. In July 2018, SERCO commenced the process of reclaiming properties from those whose asylum applications had been decided and were no longer entitled to support. This was after a similar process had been successfully rolled out in the northwest of England. The process of issuing a lock change notice, if an individual refused to leave a property at the end of their entitlement, was paused, pending a legal challenge in the Scottish courts. That pause did not affect the eligibility of people to receive asylum support, so those who became appeal rights exhausted or were granted leave to remain continued to receive the normal letter asking them to leave their accommodation. However, in that period, SERCO did not follow this up by proceeding with lock changes if the individuals declined to leave. In April of this year, Lord Tyre dismissed 2 cases brought against SERCO and the Home Office, contesting this course of action. An appeal has been lodged and is currently sisted. As the cases were dismissed, SERCO are now moving to resolve the circumstances of those staying in SERCO properties. It is right that they should do so. I finally wanted to clarify the operational process, which I have also set out in my recent letter to Glasgow MPs and MSPs. I give way to the honourable gentleman.
Giving way. She says that it's right for SERCO to act in that way, given Lord Tyre's judgment. Surely it would be right for SERCO to wait the outcome of the further appeal. And secondly, could I also ask her to address the issue of funding for local authorities, with the Home Office having undertaken to work with local authorities to assess the impact on their resources that dispersal has? Why is that work kicked into long grass?
Yeah.
The legal action, which was started last year and the judgment concluded in April of this year, did not in fact provide a barrier to SERCO continuing with this activity. They chose to pause it. The further appeal does not provide a barrier, and the judgment was very clear, and it is right that SERCO should seek to make sure that accommodation designated for asylum seekers is available to those who fall into that category. I must make a little bit more progress. Each week, SERCO has provided the Home Office with a list of individuals who are overstaying in properties. The Home Office carefully checks this list against internal databases to ensure that the persons have not lodged further submissions or new applications to remain, and that there are no known obstacles that prevent those individuals from leaving the United Kingdom. Once this is confirmed, the information is relayed back to SERCO and a notice to quit is served, providing 14 days to leave the property. At the end of this period, and if needed, a lock change notice is served, providing 7 days in which to leave the property before the locks may be changed. The first notices were issued on the 20th of June 2019. I will indeed.
Well, I'm afraid the Minister can hold this line that the first letters were issued on the 20th of June. But I will place in the library letters that were issued before that. So can the Minister, has she clarified from SERCO when they issued their first letter? Because the 20th of June date is quite simply factually inaccurate.
Well, as I set out earlier in my comments, and I can't find the particular place easily to hand. I made it very clear that SERCO continued with the process because actually there was a cohort which came to everybody's attention in the summer of last year. But between that time and now, there have been additional asylum seekers in SERCO accommodation who have submitted new claims which have then been found not to be substantiated, and the process is not one that is set in aspic. It continues the whole time. So there will be different individuals who have come in, there will have been new claims made by some of this cohort, and it's important to reflect that although the Honourable Gentleman refers to other individuals who have received notices to quit, which may have been because their claim was found to be warranted, they were given refugee status and then needed to move on into mainstream accommodation, there will also have been those whose asylum claim was found not to have been substantiated and they were not in need of protection. It remains the position that all of the cohort can apply for Section 4 support at any time, and if they do, the process will be suspended until the application is considered and appeal against its refusal is decided. I think the Deputy Speaker is concerned that we're about to use more time than I am permitted. I am proud of the contribution our country makes to providing accommodation and support to those seeking asylum, but when the courts have decided a claim is not well-founded, it is important that this support is only available if the individuals take reasonable steps to leave the United Kingdom or, as I've mentioned earlier, there is an obstacle to their departure. I am, of course, always willing to consider practical ideas about how we can further encourage those whose asylum claim has been refused to accept the offer of support on these terms.